When a person is arrested for DUI, they will get a citation telling them to go to court on a particular date. Sometimes this is a couple weeks after the arrest, sometimes this can be a few months after the arrest. But that's going to be the initial court date, what we call the arraignment. That's where we go in, we enter a plea of not guilty, we get all of the documentation that the prosecution has collected on the case, and we set the matter for further proceedings. Two things a person should know. First of all, if it's a misdemeanor DUI, their attorney can appear for them. That means that they probably will never have to go to court unless the case goes to trial. Secondly, this arraignment is not the date that the case is going to be resolved. This is just the start of proceedings. A lot of people have had traffic tickets before, and if you've had a traffic ticket, you know you go to traffic court, you go before the judge decides that very day what's going to happen, you go home and the case is over. It's not like that in a DUI case. The court date is just the initial court date in what is likely to be several court appearances. That's going to take course over several months. And during these subsequent court appearances, which we call pretrials, these are times where we go in and we negotiate with the judge and the prosecutor, we collect more evidence, we run motions, and we see if we can resolve the case. Ultimately, there's only three possibilities as to what can happen in the case. One, the case can be dismissed, which is obviously our first choice. Secondly, there could be a plea bargain. And a lot of times at these pretrials, the charge will be reduced to a lesser offense and the client would plead to a lesser offense. The third possibility is that the case could go to jury trial. That would be the final stage, and at a jury trial, a jury would be summoned to hear all the evidence and decide whether the person is guilty or not guilty.